regulate Waqf, and they said that after obviously going through the Sharia principles in relation to Waqf, they said perpetuity in donating certain corpus would be essential for creation of Waqf. Then the court examined what was the difference between trust and the Waqf, and they came out on a specific fact. They came at a conclusion saying that no, this will have to be treated as trust because the benefit was open-ended for general public, not for Muslims, and though the purpose was pious. 1954 onwards, there was centralized legislation to regulate Waqf. But till now, in India, there is no central legislation which regulates Hindu endowments. I am really thankful to the people who took initiative to discuss issue of Waqf in the background of Indian legislative changes that has already taken place and that is under scrutiny of the Supreme Court now. Since I have to largely cover a very widespread issues that are involved in the entire debate of Waqf, Dr. Nizam Siddiqui is free to tell me when I am crossing the time limit, and then I will continue in 3 minutes. Dr. Mahan Mirza has already given an overview, I just heard, that how the concentration of wealth has taken place in the recent past and how the obligations have shifted to different classes of people. And Dr. Ibrahim has spoken about importance of Waqf. So, right now, when the entire world, individuals, corporations, even the governments are working whole time to concentrate wealth, I must congratulate the hosts here, Alia of university as well as American college, that they have taken up an issue which goes completely contrary to this. It doesn't talk concentration, it doesn't talk about, the issue doesn't talk about familial succession of the concentrated wealth. Waqf, as in the entire country, in India also, is considered to be a religious concept, a form of ibadah, an expression of faith, and this is our understanding that it is not just a regime to regulate property rights. It is a religio-social institute which extends the benefit to the needy as per the intention of the Waqif. So that is the concept, and in this background, if I talk about Indian legal system, the system has tried to shape up the legislation as well as the court's jurisprudence, but many a times, as most of the institutions commit error, even those institutions have committed errors. And as it was felt, it has been corrected through legislation as well as judgments. And that's how this long journey of about 200 years has to be explained, how this institution started getting regulated from the time of Britishers after independence from 1947 till 2025, when we are faced with new amendments in the existing legislation. That is the background. So first of all, see, we find certain regulations of 1810 and 1817 by British Crown, which generally tried regulating religious endowments, but obviously because of certain mismanagements, there were certain more legislations in 1863 and thereafter till 1920, there were charitable religious trusts, etc., that had come into existence, and in the meantime, parallelly, the courts, high courts established by British Crown had started giving different judgments, and from 1913 onwards, certain Waqf specific legislations had also started coming in. So that's how this legislative history, pre-independence era, started emerging, and we started understanding Waqf law not with the perspective of Sharia, but also through the perspective of the judicial process. 1894 was one of the first judgments where the court decided that, see, if somebody creates Waqf and the benefit is reserved for the children and thereafter their children and further to their children, and ultimately if nobody is left out in the family, then it goes to Waqf. Then the court said that the benefit to the poor is too distant from the person who created the Waqf. So if this was the intention of the Waqf, then this will not be treated as Waqf. So that's how this debate started. And that time, obviously, because demography of the country was different, so people took initiative and certain legislations were passed where the concept of Waqf al-Awlad, which is essentially a religious concept which was sought to be brought in through legislation. So then the courts started interpreting what would constitute a valid Waqf. What would a person do with intention to give the benefit to public at large, and that will become Waqf. So this process essentially started through judicial forum, and sometime the court said that, see, when the purpose was essentially charitable within the parameters of Islamic charity, then irrespective whether you are saying it is Waqf or it is trust, or you don't say whether it is Waqf or trust, it will be treated as Waqf. So this was one line, and the other line was that you create Waqf, but the benefit goes to your own family, and thereafter to next generation, and then the ultimately to the poor, then probably there will be a different consequence of it, and probably the constitution of this Waqf will not be treated as Waqf. It will be a familial succession. 1925 was a time when one of the high courts in India, which used to be the highest court within the territory of India, they said that there are different essential conditions to create Waqf, and they said that after obviously going through the Sharia principles in relation to Waqf, they said perpetuity in donating certain corpus would be essential for creation of Waqf. So if there is no perpetuity attached with giving away, in the process of giving away of the corpus, then we may not treat this institution as Waqf, and sought to create distinction from gift, because lot many people were giving gift, and the people who got the benefit out of that gift started asserting that this is Waqf. So the court said, no, sorry, the concept of Waqf is altogether different, and gift is something else. And in that debate, there was another term which came, was trust. Because Britishers had the jurisprudence coming from common law system. Legislation was already there in India, and they had said that, see, once somebody has created trust, that cannot be treated as Waqf, because trust is completely different, Waqf is different. So a time came when the court said that, sorry, this is not whether it is termed as Waqf or trust. If a Muslim has created some institution which is charitable in nature, and the purpose is to serve exclusively Muslims, then irrespective of the fact whether it is termed as trust or Waqf, the courts must treat that institution as Waqf and not the trust. And sometime they said later that obviously in the process of creating distinction, they said that Muslim law relating to trust differs fundamentally from English law, but under Muslim law there is no prohibition against creation of secular trust. Usually followers of Islam would naturally prefer to dedicate their property to Almighty and create Waqf in the conventional Muhammadan sense, but it is not to say that the followers of Islam is precluded from creating public religious or charitable trust which does not conform to the conventional notion of Waqf and which purports to create public religious charity in non-religious secular sense. So now this observation of court has become important, because when we come to 1925, when the Waqf Act has been amended, within the Waqf jurisprudence, concept of trust has been introduced to say that if somebody wants to, essentially it has given permission that if somebody wants to run a mosque or qabristan through trust, they are free to do it. This was not the option earlier prior to 2025. So once we talk about Waqf, from 1925 we recognize within the judicial process that if somebody has created Waqf, perpetuity being the main characteristics of giving the property in Waqf was essential condition, and that's how the concept of once a Waqf, always a Waqf had come into existence. Now that jurisprudence, I think, is sought to be disturbed by introducing the concept of trust. As far as legislative history is concerned, the first legislation that came, and then thereafter 2-3 more legislations came, which legislated what would be treated, what would the definition of Waqf would be. The courts had already stated, but in 1923, when the Waqf was defined, it was defined as permanent dedication by a person professing Mussalman faith. The word Mussalman was used. By any property for any purpose recognized by Mussalman law as religious, pious or charitable. And this was one part of the definition of Waqf. And the second part was what would not amount to Waqf. And that it stated that but does not include any Waqf such as under which any benefit for the time being claimed for himself by a person by whom the Waqf was created or by any of his family or descendants. So in a way, some kind of Waqf was excluded from the scope of Waqf by definition itself. And that's how this debate of Waqf al-Awlad and Waqf came into existence. And thereafter there was a legislation called Sharia Application Act of 1937, which essentially did not regulate the concept of Waqf, but simply stated that those issues, there are certain issues relating to Muslims when the parties are Muslims, then Muslim personal law will be substantive law through which it will be regulated. For example, if somebody is Muslim and somebody has to pronounce talaq or the familial succession, then the Sharia will be the substantive law to regulate. So in that list of items, Waqf was also one of them. So about Waqf, there was a clarity that Sharia is the substantive law which will regulate the Waqf. And that law even today exists. So till the time there is contrary statutory legislations, there is a gap, then Sharia will come in. And through Sharia, we will try understanding what way the interpretation of Waqf jurisprudence should go. So this is by and large, there was one act legislation in 1943 which was given effect to on different dates in different part of India, and till 1947 these 3-4 legislations regulated the Waqf law, and parallelly, as I stated, the courts kept interpreting Waqf jurisprudence. Once we talk about Waqf law in India, then it is also important that because Muslim population being 15 or 13%, largely the Hindu population, there are a lot of temples, mutts, ashrams. So we started also to see how the Hindu religious endowments are regulated. 1954 onwards, there was centralized legislation to regulate Waqf. But till now, in India, there is no central legislation which regulates Hindu endowments. Though there are certain provincial legislations, and there are a lot of similarities in provincial legislation as well as the, if we put on the other side, Waqf and the provisions in those Hindu religious endowments. But like we try understanding Sharia law to understand Waqf, we tried finding out what is in fact Hindu jurisprudence which will regulate the statutory law finally. So very interestingly, though it's yet to be argued in the Supreme Court because the final hearing has not taken place, we found that almost 90% substantive law in Hindu religion is also similar like we have in Sharia. In Hindus, there is little difference that there is no line of demarcation between religion and charity. Charity is regarded as part of the religion. We probably understand Waqf in a little different way as I have just placed before you. Hindu religion recognizes existence of a life after death, and karma in the present life shall have correspondingly good or bad result in the life after death. A religious trust amongst Hindus could arise when property or fund is dedicated, like we have dedication of Waqf, or set apart for any particular object of religion or charity. For every act of dedication, there are two essentials. Like in Waqf, there are two essentials. One is that we declare. Second, expressly or impliedly, physically, or by implied permissions, we permit people to use that property. So, second aspect in Waqf is handing over of possession. Handing over of possession may not necessarily always mean that you are formally giving the possession to somebody. If somebody has set up a mosque and it has been opened for general public, that amounts to giving possession to the public at large. So one is declaration of intention, and second is to give possession. Possession has different connotations. So for Hindu religious endowments also, there are two essentials. One is sankalp, which is translated as a formula to resolve. It is essentially treated as Waqf. So that's how things have emerged. See, it was 1956 when the court said that only somebody's expression to dedicate would be enough. And has been used as qabristan or graveyard, and the owner did not object to it, then it became Waqf. So that's how in post-independent era the Supreme Court started about how the Waqf could be created in Indian system. 1962, when an issue went to the Supreme Court, where the issue was that Nizam of Hyderabad created a trust, and in the trust he stated that the benefits of this trust will go to general public. Then the issue was that whether this property should be treated as Waqf. or whether it should be treated as English trust. Then the court examined what was the difference between trust and the Waqf, and they came out on a specific fact. They came at a conclusion saying that no, this will have to be treated as trust because the benefit was open-ended for general public, not for Muslims. And though the purpose was pious, many of the objectives overlapped with the objectives as recognized for Waqf within Islam, but it was for general public, so it can't be treated as trust. 1972, 77, Justice 76 in fact, Justice Fazal Ali, who was one of the great judges in the Supreme Court of India, then he further laid down a principle to say that no particular form of declaration is necessary. Declaration can be presumed from the conduct of the founder, whether express or implied. Waqif must divest himself completely from the ownership. Divestment can be inferred by delivery of possession of mutawalli or imam, even if no actual delivery of possession. If somebody is using it as mosque, then it becomes public Waqf. So that was the understanding, and at the same time, Justice Beg, a few years later, gave the similar verdict for a Hindu religious endowment like temple and mutts and ashrams, saying similar things about how Hindu religious endowments will come into being. Thereafter, 1998, property granted by way of service imam for the purpose of recognized Muslim Waqf law as pious, religious or charitable would constitute Waqf. 1999, again permanent dedication etc. were recognized, and the time came when 2026, then again that 66 debate of trust and Waqf came in, and then the court gave a long jurisprudence saying these are the distinctive factor which will make an institution Waqf vis-a-vis trust. So this has been broadly the concept, the concept as has been understood by institutions in India. As far as statutory legislation post-independence is concerned, after 1954, there was 1995 legislation which comprehensively superseded the earlier legislations, and then they gave a detailed mechanism through which a Waqf could be created, regulated, adjudicated, etc. All the mechanisms were put together, that from initial constitution of Waqf, then regulation, registration, adjudication, a special adjudicatory mechanism was created. So all these have been there. Unfortunately, the Waqf by user was not part of 1995 Act, which was brought in 2013. In between that, Ayodhya judgment came, which also recognized Waqf by user. But in the last 3-4 years, for whatever reasons, there has been a lot of talk about why the Waqf administration should be treated distinctively and why there should be additional protection to the Waqf properties, which according to me is not a justified debate, because for most of the other religious endowments, similar protections are there, and the only difference is that as far as Waqf is concerned, there is centralized legislation. For other religious endowments, there is no such centralized legislation, but still On the same line, there are legislations in different territories of India, and that has resulted in bringing a new amendment which substantially changes the statutory mechanism, and it changes in different aspects. It starts when you have to create a waqf. So there are different provisions that have been brought in, including trust, how it has to be regulated. There are substantive changes. Since the law has been changed, it will directly affect adjudication. So the adjudicatory mechanism has not been substantively changed, but the effect of the other changes are such that the adjudicatory process will also have serious effect. As far as substantive laws are concerned, for example, a waqf by user, that has been completely taken away. Though by way of interim judgment, the Supreme Court has clarified that the future waqf by user will not be permitted, rather not recognized. But as far as past waqf by user, if they were registered with the appropriate authorities, that will be permitted. There are ways in which certain waqf institutions' management are going to be conducted. There is change. The people who can create waqf, there is change. And that is the reason probably that the Muslim population in India has raised objections to these amendments, and it has gone to the court after whatever objections have been registered through different mechanisms. So at the end, the Act's imposition of non-Muslim administrators while in the process of managing the waqf properties, somebody required to show and demonstrate that he is visibly Muslim as a mandatory criteria to create waqf. These provisions, there are many others. Many people feel that these are very discriminatory provisions because this is specific to the waqf and not in any other religious endowments. And since this legislation is in the Supreme Court and I also appear as one of the lawyers, so how the courts will go, we can't predict it right now. We can only understand that there is enough jurisprudence given by the same court to say that these provisions are discriminatory, disproportionate, and they require a review through the competent legislation. I feel that there are many provisions on which finally we'll be able to succeed and protect the waqf institutions. So this is broadly the legislation as well as judgments. And as the conference goes further, probably I'll be available to answer any question if I'm asked. Thank you very much.